Hello, everyone, and welcome to our webinar on the DOL Fiduciary Exemption. We have two great speakers for our webinar today. Jenny Eller is a principal at Groom Law Group, and she is chair of Groom's Retirement Services Practice Group and Fiduciary Practice. Jenny also worked on our comment letter to the DOL on the proposed fiduciary exemption. Allison Itami is also a principal at Groom Law Group, and she also has extensive experience working with advisors, other plan service providers, and employers on ERISA and retirement issues. So thank you both for joining us today. And please feel free to ask questions as we go along. As Megan said, you can put those in the chat function and we will do our best to get to those. So with that, I'm going to turn it over to Jenny to get us started.
Great, thanks, Sarah. And thanks everyone for being here with us today. Allie and I are really pleased to be able to speak with you about this new exemption. And it's particularly how it applies to investment advisors. So starting here on slide 3, just to go over our agenda, we're really going to focus on the exemption and the things that go along with it as they apply to you all as advisors. We'll do a brief overview. We'll talk about the preamble to the exemption. Many of you will remember in 2016 that the DOL issued new regulations that defined what it means to be an investment advice fiduciary for purposes of ERISA and the code. And it's really important to get this understanding of this particular definition, and there's some additional language in the preamble. You may remember that 2016 rule was struck down by the Fifth Circuit. The whole thing sort of went away, and this is a little bit of a preview about how it's perhaps coming back and in what ways. We'll talk about, kind of whether and to what extent the exemption is relevant to everybody and what the alternatives might be to compliance. And then we'll go through the exemption itself and some of the key conditions, particularly how they might apply to you all. And then we'll talk about some opportunities that the exemption might present. As you know, exemptions are generally good things in that if you can meet their conditions, then you can engage in transactions that are otherwise not permitted under ERISA and the code. And then we'll talk at the very end a little bit about next steps, what we might expect to see from the department going forward, including kind of how that dovetails with what we might expect to see from the SEC. Okay, so moving on to the next slide, which is really just kind of an overview in the sense that kind of putting the two fiduciary definitions side by side, or investment advice definitions side by side. In general, the range of activities that constitute investment advice under ERISA and the code is narrower than the range of activities that are investment advice under the Investment Advisors Act. The definition matters in particular under ERISA and the code because all of the key requirements and obligations are imposed on people who are acting as fiduciaries. So the broader the net of folks who are acting as investment advice fiduciaries, the more instances in which the requirements of ERISA and the code apply, and the more instances in which you might need to use the exemption. Moving on again to the next slide, slide 5. As I mentioned, we really wanted to talk about the preamble. So exemptions are like regulations. They're issued in notice and comment. They can either be issued to individual applicants, or that, as this one, they can be what's called a class exemption and issued to the world at large. Anyone who can meet the conditions of this exemption is eligible to use it and can get the relief that the exemption provides. And as we'll talk about, what that is here is the ability to receive compensation as a result of investment advice that you provide to an ERISA plan or an IRA or a participant or beneficiary. So normally ERISA fiduciaries are prohibited from receiving compensation as a result of the exercise of their fiduciary authority, including providing investment advice. And one of the real key places that what the preamble talked about is really important for us to focus on, and that is rollovers. And in particular, the extent to which a person might be deemed to be a fiduciary when making recommendations or having a conversation with an individual plan participant in, say, a 401k plan, about their options for taking money out of the plan or taking what's called a rollover. In 2005, the Department of Labor issued an advisory opinion to Deseret Benefit Services. And the question there was, when I'm speaking to a participant about taking money out of a plan, in what situation might that be investment advice under the ERISA definition? And what the department said, somewhat helpfully in that opinion, is, well, unless you have an existing fiduciary relationship with the plan, you can talk to participants about taking a rollover. You can make a recommendation that they take a rollover, even if where they put their money, their investment in the IRA, benefits you. And none of that is fiduciary investment advice. And what that has meant is that for the most part, folks have been able to provide recommendations to participants who are eligible to take a distribution from a plan, that they take money out of the plan and roll that money into an IRA, and none of that has been subject to the fiduciary definitions or has been subject to ERISA's prohibited transaction rules or the rules of the code. And as I mentioned, the 2016 DOL Fiduciary rule change was primarily intended to capture this activity. As you all may know, there's more money in IRAs, $7 or $8 trillion than there is in the DC plan market. And that's primarily by reason of money rolling out of the 401k plans into IRAs. So it's really important to understand that one of the key things the department did in this preamble is to say that they no longer believe that the analysis in the Deseret letter is correct, and they are not going to apply that analysis. They believe that the better view is the same view that the SEC has taken, which is that a rollover recommendation is something that can cause you to be a fiduciary if you meet the fiduciary advice definition. So they rescinded that letter. For people who have been relying on that letter, the department said they will not pursue claims or treat as a violation any advice that was covered under the opinion they gave in the Deseret letter. So it really covers from 2005 until February 16 of this year, which is the date that this exemption became available. So what else did they say in the preamble? Moving on to the next slide, Megan, slide 6. One of the things they said is, well, so we've taken off the table kind of the rule that was out there that unless you have a fiduciary relationship with the plan already, you're not going to be an advice fiduciary by reason of giving a rollover recommendation. Well, so we know what doesn't exist anymore, but what is the test? In order to be an investment advice fiduciary, a person has to, for a fee, give advice or make recommendations about the advisability of investing or about the value of securities or other property. They have to do that on a regular basis, and they have to do it pursuant to a mutual understanding that the advice will serve as a primary basis of the person's investment decision, and that the advice will be individualized to the needs of the plan. So those 5 elements have to be met. And one thing the department did in the preamble is give us a little bit of a preview of what might be called an expansive view of that definition. So in the past, we had thought, well, gee, in order for something to be given on a regular basis, you have to have kind of an ongoing relationship. I think the department said, well, and so as a result, you sort of had this concept of one free bite at the apple, one free piece of recommendation, because the first time you give a recommendation, even if it might meet all the other pieces of the definition, but the first time you do something, it can't be a regular basis. Here the department said, we're not so sure about that. In fact, if you provide a recommendation and you anticipate that you're going to have an ongoing relationship with the person you give the recommendation to, then that first bit of advice could be the beginning of a regular basis relationship. And that's pretty new. But they did say, yeah.
Can I ask you a question on that regular basis point? One question we got is that, you could have a situation where after the rollover, the advisor may be providing discretionary management. And so, that at this point in time, because this, and we're going to get into this exemption really applies to non-discretionary advice. But the DOL seems to be taking a broad view on regular basis. The point is if you're providing advice to a client on a rollover, and the expectation is you're going to be continuing to have a relationship with that client, even if it's in this discretionary capacity going forward, that you may need to rely on this exemption just for that rollover transaction, right?
Correct. I think of it, example is sort of like, we're standing outside the swimming pool. I say, the water in my swimming pool is fine. Once you get into my pool, I will be your discretionary advisor. I will take care of you when you're in the pool. And the question is, do you jump into the pool by yourself? Do you do your own rollover? Do I say, hey, I recommend you get into the pool. The water is fine. So yeah, I think what the department said is, if you imagine that if you intend to have an ongoing advice relationship, then that could be the first, then a rollover recommendation could be the first of a regular series of recommendations. And the question I think that you're bringing up, which is a good one as well, if I'm going to be a discretionary advisor to that IRA after the fact, then I'm not going to be giving them recommendations. I'm going to be managing their money. I think what the department would say is what they mean is if you intend to have an ongoing relationship, whether it's discretionary or advisory with that person's IRA, then the fact that the recommendation you give to them to roll out of the plan is sort of your first recommendation, that doesn't mean that you don't meet that part of the test. You can still meet that regular basis part of the test, even if what you're going to be doing is providing discretionary advice down the line. So I don't think that's going to help you. What they talk about is sort of sporadic, like if I give you advice to move to a rollover, but you're going to have a self-directed rollover IRA, and 3 years down the line, you come back to me and ask me for some other advice, then you're not going to connect that dot back to the original rollover recommendation. But for many advisors, that's really not what you're looking at in terms of what the IRA is gonna be doing. In the past, people have thought, well, if you have to have a mutual understanding about this relationship, that's part of the investment advice definition, then if I say, look, I just need you to know, I'm not acting as a fiduciary when I make this recommendation. You should not think that we have a mutual understanding that my advice is going to serve as a primary basis for your investment decisions or that it will be individualized. The department said, look, we're not going to just look at disclaimers. We're going to look at the relationship as a whole. So if everything else about the relationship indicates that it would be reasonable to think that there is a mutual understanding that advice is going to take place, then the fact that you have a disclaimer in a contract is not going to stop you from meeting that part of the test. And then there's a primary basis. They really kind of looked at a materiality threshold. Would a reasonable investor look at this advice and take action on it? Many of you who are familiar with the 2016 rule might remember all of the sort of gyrations we had around hire me, around this concept of if I make a recommendation to a potential client that they hire me to be their discretionary advisor, or they hire me to be their investment advisor, and is that a recommendation as to securities or other property that I might then in the future recommend? And it had this kind of cascading or ripple effect the department did address this somewhat in the preamble and said, you know, in general, if you have a very kind of generic statement that says, hey, I've been helping Joe with his IRA for years, and, you know, I think I would be a good person for you to talk to if you're ever interested, that, you know, I'd like you to consider hiring me in the future. That's not necessarily the same thing as recommending securities. But if you manage a fund or a certain type of fund, and you say, you know, I think that you should hire me, and hire me is synonymous with hire me to manage real estate in, you know, core, or hire me to manage fixed income, or this type of fund, then, you know, you might in fact be making a recommendation as to the advisability of investing in particular types of securities.
Jenny, we have a question to go over the 5-part test again. If you could just walk through those 5. And again, this is for fiduciary investment advice, not discretionary management. So the 5-part test, but that 5-part test is what you're going to be looking at in the context of rollovers if you're a discretionary manager, right?
Right, because you never really exercise, very rarely, perhaps under a power of attorney, but you never really exercise discretion to cause somebody to roll out of their plan. It's always going to be as a result of investment advice.
Right, and the reason why it triggers the prohibited transaction issues is that you're getting new assets. Even if you have a client for which you've been providing management, discretionary management, that advisor now wants to move money out of the advisor wants to advise the client to move money out of the 401k into an IRA. Well, now the advisor's got more assets to manage, causing the advisor to earn more in fees, even if it's a flat level fee. So it's
Right.
all about this rollover, so that the 5 parts are mentioned, I know in our earlier slide, but if you could just mention those again,
Sure.
Somebody had asked about it, so.
Sure, and that is a great point. We want to know if you're a fiduciary, because fiduciaries can't cause themselves to receive additional fees. And you receive additional fees when someone rolls out of their plan and into your IRA, for instance. So you are an investment advice fiduciary if, for a fee, you provide advice as to the value of securities or other property, or you make a recommendation as to the advisability of investing. If you do that on a regular basis, if you do that pursuant to a mutual understanding between you and your client or prospect, that your advice will serve as a primary basis for their investment decision, and that the advice will be individualized to their needs. Hopefully that's helpful. Let's see, then we're on to slide, sorry, on to slide.
I think we're on slide 7.
Thank you.
Right? So I think I was going to pick up here, if that's okay.
Great.
So we're going to take a little bit of a pause and say, okay, Jenny, what you just described was scary. And maybe I fall in that category, but I'm not entirely ready to jump in the pool with you. I don't really want to, go through and do all the bells and whistles of PTE 2020-02. So what are my alternatives? And I believe that Sarah has mentioned the possibility of doing future lectures to focus on some of the alternatives in more depth. And so for purposes of this particular webinar, we're mostly going to focus on avoiding fiduciary status and the temporary non-enforcement policy. So avoiding fiduciary status is a great alternative. You really have 2 ways of avoiding fiduciary status. You could have self-directed rollovers only. So you could look at your book of business and say, you know what, I just don't give that many rollover recommendations. And going through all of these conditions that Jenny and I will touch on in a few minutes just doesn't make sense for me. I'm going to avoid it by saying, I can't give you any recommendations about what you should do with your money in that plan. I can't tell you to roll it over. But if you tell me I'm going to roll it over, then I can tell you how to invest it or how to manage it. So that would be, taking a self-directed approach.
And Allie, can I stop a minute on that? The reason that doesn't raise the exemption is if the client says to me, the money's coming in 3 days, I've decided to roll over, so the money is coming to you, advisor. Well, once the money is in the account, then the advisor is collecting typically, an asset-based fee for that. And so now you're not in any kind, you haven't provided advice on it. You're collecting on that IRA the same fee that you collect for managing other assets. And so it's not triggering any prohibited transactions, right?
Exactly.
Yeah, and I would say
and then
we've gotten that question coming up in anticipation for this webinar. We did get a few questions on that where people were saying, I'm not really providing advice on whether the client should roll out of the 401k plan into an IRA. The client's saying, I want to do that because I want to consolidate assets. So that is something that we've been hearing.
Perfect. And speaking of wanting to consolidate assets, the other way to avoid fiduciary status is our old friend, Interpretive Bulletin 96-1. This came out from the DOL back in 1996 and covers different activities that you can undertake without actually providing investment advice. So it's generally referred to as education. So you can provide various sort of relatively generic ideas about accounts that might be able to stay on the side of education. So you might be able to say, listen, I've looked at your plan and, underneath your plan, you can't invest in annuities or something like that. You can make factual statements about what's available for investments under the plan. You can make factual statements about, there are some, tax advantages and bankruptcy advantages to staying in the plan. There are certain, delineated things about the plan you can mention, and then other investment concepts that you can mention without crossing the line. And I think that this area is where we're going to see a lot of people try to land. It's definitely easier than complying with the exemption. It's riskier because if you fail to stay on the right side of the education line, then you're sort of flying without a net. So it's definitely a riskier proposition to try to do education only, but it is a very popular way to go. And definitely something that we expect to see a lot of, particularly brokers, try to stay in this area.
Allison, one question that's come up through the chat, how would you document that the client is making the decision, that it's self-directed?
Well, there's no magic formula. I think back in 2016, when we were working on this with a bunch of clients, we came up with a lot of different ideas, including checking a box within your own, record-keeping system and saying this was self-directed. Whether or not that's going to hold a lot of water with an auditor from the DOL, who knows? We also had some people who wanted to give, a notice to the client and have them actually physically acknowledge, yes, I made this as a self-directed and I've signed it. That's fairly bulletproof, I would think. But are people actually going to go to those extremes? I'm not sure. They might. And I think some of it also depends on, your size and your type of practice. If you're giving a few rollover recommendations a year, but you're mostly managing once they've rolled into the IRA, maybe that's doable. Maybe it's perfectly fine for you to sit down with a client and get them to, sign saying, I made this self-directed. But if you're a larger shop and it's happening all the time, it might be harder.
Yeah, there was a good question that came up then following the chat is the fact that you have a lot of rollovers coming in, do we think the department's going to come in after the fact and say, you have received a lot of rollover dollars, therefore you must be giving investment advice? And Allie's smiling because she and I have seen something a little bit like this. And I think there is some concern. Now, if you do have, the right documentation, you might be able to beat that back. But I do think that, if you have people reaching out to prospects or clients who have money, in plans and then they roll over, that's really going to be a little tricky to defend. If sometimes I hear from clients, I'm an asset manager. Sometimes I do rollovers as essentially an accommodation. Someone who I already have a relationship with comes to me and says, look, can you manage my IRA money, please? That's one thing. But if you have as Ali said, a much bigger volume, it's just harder to police and it's harder to document. So I wouldn't say that the department has certainly not said they're going to go out and look at kind of the the results to decide whether you're providing advice. But if you have a decent volume, I think you should expect to have to really show how you're using an education model, what your scripts are, what the requirements are for training and that sort of thing for your folks, and really to be able to defend that pretty well.
Yeah, if you come to the end of it and lo and behold, I've never given a recommendation, but a rollover recommendation, but 2,000 people did roll over, that could be a little bit difficult. So just quickly, the other way to avoid this exemption would be to rely on the temporary enforcement policy. Now, this enforcement policy came about in 2018 and requires that you be working in good faith to meet the impartial conduct standards as they were defined back in 2016. This is definitely sort of a stopgap measure. If you're already working on that basis, you can probably continue to rely on the non-enforcement policy through the end of the year. But it's not something that you should start building a system out for now, because it's only going to go through the end of the year. And it doesn't seem likely that they are going to offer any extensions on this. We have the exemption as an alternative, and that's where they really would like you to be going. So if we move on to the next slide.
We did get one interesting comment about the self-directed point, that it may be helpful to document, make sure the client has confirmed it so that the client doesn't in a couple of years say, well, this was your suggestion. So I thought that was an interesting point.
It absolutely is. And, don't want to be us against clients, but, recollections can differ. And so having it in writing is always music to an attorney's ears.
One other question that we received is, unlike the SEC and FINRA, historically the DOL does not examine or audit advisors or broker dealers other than in connection with the plan audit. Has that changed? Wondering if you're seeing, in terms of how this is going to be enforced or examined for, if you've been thinking about that.
Absolutely, that has changed. The Department of Labor very much, they have figured out that if you want to get to see what happens with a lot of plans, you can go to an asset manager, you can go to a broker dealer, you can go to a record keeper. And so those sort of book of business kinds of investigations are really quite common now from the department. So that has changed.
I think one interesting question too will be the SEC, you know, they have broad review of advisors. And so they may also be asking, how did you determine that those rollovers were in your client's best interest? So it'd be interesting to see where that goes. So, all right. Thanks.
Yeah. So Jenny, I actually can't remember where we stood on who was doing this slide, but I will take it unless you object. So the actual exemption, you have decided, you know what, I am providing ERISA covered investment advice, and I would like to use this new exemption. Okay, the new exemption is really quite broad in the types of compensation that you can receive. You know, obviously for advisors, you're often receiving an assets under management, flat fee arrangement. So you're less interested in all of the various variable compensation, but it is nice to know that it's there, that you can find relief for that type of compensation as long as it's in connection with non-discretionary investment advice. And as we've spent the whole first part of this webinar talking about, for this group, it's most likely going to be a rollover recommendation that causes you to want to rely on this exemption. There is some relief for principal and riskless principal transactions, but probably not as interesting for this particular audience. So we can move on to slide 9. Who is allowed to use this exemption? Financial institutions who have investment professionals working for them can use this exemption. So financial institutions include broker-dealers, banks, insurance companies, and RIAs. And who are retirement investors? So unlike Reg BI and unlike the 2016 version of this, retirement investors are pretty broad. It's not just retail. It could be a very large pension plan. It could be a defined contribution plan who you're providing lineup advice for. It could be the particular participant or beneficiary with respect to a rollover. Could even be an HSA. So moving on to the next slide, we look at the exclusions. One of the biggest disappointments of the exemption is that it continues to exclude what they call pure robo or digital advice. So advice that is not somehow a hybrid of a person and an algorithm. We really had hoped that that would be covered, because obviously it is a lot easier to create an algorithm or a tool that helps walk you through a rollover than it is to necessarily provide that, in person. The other people who are excluded from relying on this exemption are discretionary managers, but only in their management of the IRA or the plan. So you could, as a discretionary manager, you can still rely on this if you're providing a rollover recommendation to get into the discretionary management. You are absolutely still allowed to use this exception.
And Allie, one thing I would mention in the preamble, they actually make this point specifically, is that if you're a discretionary manager and you do not need this exemption before or after the rollover, can you use the exemption just for the rollover? They said, yes, you can.
Not only can you, but
so you
might have to, right?
That's right.
You may not have another option. So it's a little unfortunate in that it doesn't have this sort of ongoing benefit to you, perhaps, but it may be the only way you can make fiduciary recommendations to get people into your discretionary products.
Right, and the reason you may not have another option is because, again, that money's coming to the advisor. That's new money coming out of the plan to the advisor. And even though going forward it will be managed on a discretionary basis, it's that point in time rollover transaction that's why you may need to rely on this. So I would mention on the digital advice, we were disappointed in our comment letter. We had asked that the exemption apply to all digital advice, and we were disappointed the DOL did not go in that direction. So
I note, however, that while we didn't get what we wanted, we did make some compelling arguments, which the department was forced to defend in the preamble. However, that they defended them by saying, we don't buy it, we don't agree. Like, we made some logical arguments, and they just stuck to their spot.
So moving on to slide 11, I think there's some real meat here. What are the conditions of the exemption? I know that Sarah had given quite a bit of thought about how some of these conditions line up with an advisor's everyday practice, you know, how it has functioned for the past decades, and how you might marry those practices up with meeting the conditions of this new exemption. So to start out with, the conditions include that you must comply with the impartial conduct standards. So the impartial conduct standards are threefold. The first is that you must make a recommendation that is in the best interest of the retirement investor. So you cannot put your own interest above that of the retirement investor, and you also can't put the interests of your employer above that of the retirement investor. You also cannot make misleading statements, and you cannot receive compensation that is in excess of reasonable compensation. So reasonable compensation is, a concept that it stems a lot from ERISA section 482. So it's something that you all have worked with for a while. Generally, a market look at what others are charging for the same services, and so that's the three-part impartial conduct standard.
And one thing I would add on the impartial conduct standards, they did say that best interest could be interpreted consistent with the SEC interpretation on fiduciary duty, which is helpful.
Absolutely. One of the other conditions is disclosure. And in particular, there's a very specific disclosure about rollovers. So in the proposed exemption, it did not have a specific rollover disclosure, but in the final, you must provide a written disclosure that documents the reasons why you believe it's in the best interest of that particular retirement investor to make a rollover. There is not necessarily a checklist in the exemption itself of what you need to consider and disclose, but there are some suggestions in the preamble, and those suggestions line up pretty nicely with what the SEC has suggested you should look at when you are providing a rollover recommendation. And I know we have a slide a little bit later that will cover some of that in more detail. Some of the additional conditions include having policies and procedures in place to make sure that you meet the impartial conduct standards and to make sure that you're providing the right disclosures. And sorry, I don't remember, Sarah, if you had a point you wanted to make on the policies or.
Yeah, I would say the policies and procedures, the thing to keep in mind there, it kind of goes with this next point, and I can mention the next point, that there is this annual retrospective review requirement. And, you think about advisors, they're subject to the compliance program rule to do an annual review on compliance, but this goes deeper than that, that annual retrospective review. It's certainly about looking at your compliance policies and procedures and whether any updates are needed, have there been compliance issues, but you also have to document that. And there's a certification requirement, and there are certain certifications that need to be made. So it goes beyond, when you're thinking about policies and procedures, I would just encourage you also to take a look at that annual retrospective review requirement and to look at those together. I would also just mention on the disclosure point, certainly, like Allison said, that rollover, the reason why the rollover is in the client's best interest, that's certainly a new requirement. And the fiduciary, acknowledging that you're a fiduciary. The other disclosure point, though, they do talk about is disclosing your conflicts and services, but they also acknowledge, the DOL says that's included in your ADV and CRS right now, so that's helpful. So it feels like in terms of what's new for advisors, it seems like the new points are the disclosures around fiduciary acknowledgement, why the rollover recommendation is in the client's best interest. Do I have to update my policies and procedures, and making sure that you follow the requirements of that annual retrospective review.
Another point about the fiduciary acknowledgement, it means you can't sort of have a belt and suspenders approach. You can't say, well, gee, we don't intend to give advice, but should we have somebody who inadvertently or gives advice when they're not supposed to, we're going to meet the conditions of the exemption. You have to pick a path. You're either not giving advice, in which case you do not have the exemption, or you are giving advice, or you're going to assume you're giving advice, in which case you have to acknowledge you're a fiduciary.
Yeah, and there was a question about, does the disclosure requirement mean that we have to give the client the reasons why we think it's in their best interest? And the answer is yes. So, so that's that's an important point.
So just quickly to touch on some of the other conditions, new concept it has been put in place here for non-compliance findings by the DOL. So if the DOL comes in and finds a pattern of non-compliance, they're going to issue a finding and say, we don't think you should be relying on this exemption anymore. And then they'll proceed and say, you cannot rely on this exemption anymore. That is pretty new, that the DOL gets to make that decision. There's also an exclusion if you or some of your affiliates have a criminal conviction that pertains to the provision of investment advice. That is relatively similar, but not exactly the same as the QPAM exclusion. There are some record-keeping requirements that are, fairly standard, and there's the opportunity for self-correction if you make the participant whole or they suffer no damages. So moving on to the next slide, this is the piece that I talked about earlier. So what do you need to consider when you're providing rollover advice? Jenny, do you want me to cover this? Sarah, do you want to cover it?
Sure, I think we've hit on a lot of these. I mean, in terms of documenting what's important in the rollover advice context, you really need to, so this, they added to the final exemption, this sort of requirement that you specifically determine what are the client's alternatives to a rollover? What are the differences between fees and expenses with the plan and with the IRA? And I will note that we're talking about this in the context of plans and IRAs. This exemption applies to IRA transfers as well. Those are also rollovers. So a couple of questions came up in the chat about that. I think that the DOL sort of has this notion that, well, gee, if the expenses are much lower in the plan, or if the employer pays a chunk of the expenses in the plan, then, you really got to kind of think twice about whether it's in the participant's best interest to roll out. I know in connection with the 2016 rule, a lot of folks were considering kind of assuming that the plan was free and really relying on this notion that you have a lot more investment options in an IRA than you do in a plan. And for some people, that might be important. That might be true. The department is pretty skeptical of that. So you just need to be mindful of that. And then thinking about different levels of fees and services and that sort of thing. So those are some of the specific rollover consideration pieces.
Yeah, and I would say the IAA, we have a rollover checklist on our website that actually includes these same considerations now, since they're things that the DOL thought about a few years ago as well, but we are in the process of updating it. Somebody did ask, would it be okay when I give my client the reasons why the rollover is in their best interest? Can I make some general statements about the benefits of our management? And I think after reading the preamble, and I'd be curious to hear, Jenny and Ellie, what you think, is that I think the DOL would expect to see a discussion of these factors. I don't know that it would be sufficient just to say, here are my services. Certainly that could be part of it, but you'd also have to be talking through these other issues in order to rely on the exemption, I would think.
I think that's right. I mean, I think one of the frustrations we have, and you all have, I think, is just this part of the regulated community is oftentimes regulators sort of have this kind of one-on-one mindset and sort of have problems with scale, right? We think of things in scale. How am I going to manage rollover advice at scale? And how can we do that? And they sort of imagine that, one by one, Joe is sitting down with Jill and they're having a one-on-one conversation and they're making their notes, and that these things happen kind of on a very small scale. And we often have to try to remind them that really we've got some large scale things going on.
I think another point I wanted to mention here in terms of the client's alternatives to a rollover, the other thing they talk about in the preamble is looking at all of the investments in the plan, not just, you've got this investment here versus this is the IRA, that there does need to be some consideration of the other, investments that are there. But like Jenny, to your point, there are typically many more investments available on the IRA side of things, but I just wanted to mention that since that was pointed out in the preamble.
Right. There's also a big discussion in the preamble about the fact that you should really be able to figure out what people are paying in the plan, that participants get 404 fee disclosure frequently, that those are often available online. And, we hear all the time from clients that, participants don't know what they're paying. They've just left their employer. And what they say is, I don't want to leave my money with that employer. And that they're not very willing to kind of sit down and have this sort of reasoned conversation about the thing to do. So I hear that all the time. The department is skeptical, again, that participants shouldn't be able to figure out what they're paying or that they shouldn't already know. So we can move to, we've talked a lot about rollovers. I want to make sure that we don't only talk about rollovers. There are some other opportunities and some other options here. So if we go to the next slide, yeah, obviously, exemptions have conditions, and we focus on the conditions, and there's some, some ones that are difficult to deal with, some are kind of painful, but there is the upside, right? That in general, a fiduciary cannot get paid for advice. I can't give you a recommendation that causes me to make more money unless I have an exemption. And this exemption allows for all kinds of payments. I can get paid because I'm managing the IRA on the other side. I can get paid as a discretionary manager on the other side, as an advice provider on the other side. I can get third-party payments. I can get direct payments. I can get, any kind of payment. So it's really sort of helpful in that regard. We have a lot of clients who have record keepers, as well as other types of services, and record keepers might be able to use this exemption to provide advice about plan lineups, and other kinds of products and services that they have available, things that maybe haven't been available easily for record keepers to do to date. For discretionary managers, if you are managing assets for, say, a pension plan, and you want to use your discretionary authority to cause that plan to invest in your affiliated mutual funds, we have an exemption for that, 77.4. If you want to use your discretionary authority to cause that plan to invest in your affiliated collective funds, we have an exemption for that, 408B8. If you want to use your discretionary authority to cause that plan to invest in your affiliate's separately managed account or a private fund, we don't have an exemption for that. There are some offsets, there are some things we can jump through some hoops, but we're sort of knitting together exemption strategies for discretionary managers. Allie and I were debating this as early as most recently as this morning. There are some things to think about as to whether it's really going to work, but we could consider that this exemption doesn't cover discretionary transactions, but it could cover advice by a discretionary manager where we don't have another exemption. I can't use my discretion to cause this pension plan to invest in my affiliate's separately managed account, but I could go to the client and say, look, I have a conflict. I can't solve this problem. I can give you a recommendation. I will give you all of the disclosures and meet all the conditions of this exemption. You decide whether you want to invest in this separately managed account. And if you do, we'll go forward together. I'll receive a fee. You'll receive these disclosures. We will have a kind of another arrow in our quiver when it comes to an exemption strategy. So I think that's something that's really interesting for discretionary managers to think of. And then the department really opened up the door to other individual exemptions patterned off of this exemption. This is a move from sort of transaction product specific exemptions to more principles-based exemptions. So they opened the door to have independent marketing organizations and similar insurance marketing entities come in for individual exemptions. You could imagine, what if you didn't want to do an annual retrospective review, but you were willing to hire an independent auditor to do one every 2 years? You might be able to go into the department and get an individual exemption that's essentially a clone of 2202, but has some different. What if you were willing to have the independent auditor look at decisions you make with respect to, or advice you give with respect to your in-house plan? Maybe you could get that covered. There's really an invitation and perhaps some opportunities here to be creative. So we always like to be creative. So we thought we'd mention those. Moving on to slide 14. We just wanted to kind of give you all a preview. This is just a copy of what the department issued when on February 12th, when they decided that on February 16th, they would let this exemption go final. There was real speculation that because this exemption was not final and effective on Inauguration Day, that the Biden administration would issue a notice in the Federal Register that said, we're going to take another look at this and we'll be back and we'd like some comments on whether we should let this go forward. Instead, they held some listening sessions. I know that IAA was part of those. And then, they issued this notice that said, we're going to let this go forward, but we are going to issue more guidance soon. We are going to look at this exemption. We're going to look at the investment advice definition, and we're going to look at other exemptions. So I think what they were saying is this is just the beginning. We told you in the preamble where we think the investment advice definition is going. We're telling you now that we're going to look at other exemptions, and maybe we're going to look at improvements to this exemption. We think, at least I think we think, I'll let Allie correct me, that you're pretty, we ought to be pretty confident in relying on this exemption as it was published. The department understands the uncertainty, and they're not going to want to say, yeah, we're letting this go final in February, but then we're going to make changes to it in August, just as people are ramping up. So we think that people should feel comfortable that this exemption is going to be available in essentially the way it was published. It is possible there will be some small tweaks, but I think they're really going to be hard pressed to come out and make significant changes. But this is, you know, we knew when the Fifth Circuit vacated the old rule that it wasn't just going to disappear, right? And this is the reality. Just like we're seeing the SEC, you know, open some things up again. The department is not done. This is just the beginning. And then,
right, and one way I think that we could, you know, be helpful as an organization is to say, listen, here's one way you can improve this exemption. You can open it up to pure digital advice. I don't think that is something we should give up on yet.
I like that.
Thanks. Well, we have gotten several questions. A couple of them relate to the timing of the disclosures, and also what if the client doesn't provide the information, you know, they want to do a rollover, but they're not providing information on the plan. What are some points there?
Allie?
Yeah, so I mean, as Jenny was saying, sometimes the person leaving employment doesn't want to go back and ask their employer, you know, how much was I paying? They don't want to go to the record keeper and find that out. Then you're kind of in a uncomfortable situation. You're probably going to want to document that you were not able to get that information. You'll want to say, okay, well, I don't know exactly what you paid in fees, or I don't know exactly, you know, the investments that are available to you. I tried looking at your 5,500 and it, you know, gave us some ideas or didn't give us any ideas, but I'm going to make a recommendation based off of what I do know. If you can come to the conclusion that you're actually providing sound advice based off of partial knowledge, go ahead and make that rollover recommendation. But if you feel like, you know what, I really can't make a good recommendation because I just don't have enough information, DOL would like you to refrain from making a recommendation. So in that case, you might have to say, listen, I just can't provide you advice. You can make a self-directed rollover if you so choose.
And from a policy standpoint, I think the department would like to see how are you policing the conflicts of the people who are delivering that information.
Yeah, and in terms of timing, the disclosures, all the disclosures have to be provided prior to the transaction. So that's the timing point. Did get a question, can an advisor receive additional compensation for providing participant level advice?
So the exemption would be available for providing advice to participants in a plan, and you can receive compensation for that. I mean, if you can think of a piece of conflicted comp that you can earn on the basis of providing investment advice, you could probably get it under this exemption. I mean, it's that good.
All right, well, we are drawing to the end of the hour, unfortunately. There are a few questions that we were not able to get to, but we'll be following up on those. I did want to mention that, you know, this exemption is certainly going to capture the spotlight this year, but as Jenny and Allie were saying, there's other exemptions that are out there. And so we are talking about having some additional webinars to talk about those other DOL prohibited transaction exemptions and related compliance issues. So stay tuned for that. And I would love to thank Jenny and Allison for your great presentation today. We really appreciate it. And again, sorry we weren't able to get to all the questions, but we'll be following up.
Thanks, everyone.
Thank you for having us.